So, estate planning is an important step in protecting your loved ones in the future. But when is it time you kind of review yours?
Maintenance is important, as we hear this morning from attorney Justin Randall with Hooper Law. Good morning.
Good morning.
So, Justin, when should people be updating their estate plan?
Um, you know, we recommend every 3 to 5 years, kind of on average, but there's a lot of other things that can kind of come into play. Anytime there's a major life change, things like a new birth in the family or possibly a death in the family, or even a new health event that happens that may change the way you want to, leave money to somebody, or maybe they're not fit any longer to be in charge of you as a power of attorney agent. Those types of things can really disrupt your planning if you don't update your plan to incorporate those changes. The problem is a lot of people think that once you have this plan in place, you're good. You can let it sit. You never have to worry about it again. But that's just not really true.
All right, you mentioned life changes. What are some of the other reasons that your plans might need updating?
Another really big thing that can happen is sort of out of everyone's control, right, is a change in the law. So, there's been some significant law changes over the last 20 years or so with estate planning. Particularly in 2014, Wisconsin adopted what we refer to as the Uniform Trust Code. So, basically, if you had a trust prior to that, a lot of the references in it may be out of date. There's new tools available to us as estate planning attorneys now that we just didn't have available to us back then, or prior to then. So, it's just without having those tools available to you, you're not getting the most out of your planning. I would say the biggest risk to an estate plan working properly, though, is not having your assets properly aligned with that plan. So, if you have a trust, you want assets titled in the name of your trust. If you have a will, you want to make sure that that will actually controls those assets by going through probate.
And Justin, we're looking at a few of the risks of an outdated estate plan. Can you highlight those and why it should encourage folks to make that update?
Yeah, so I guess I can start with the life changes. The biggest risk I see is especially when someone who was listed to inherit in their own name, so just received the money outright, suddenly had a disability, and now they may be on a means-tested government assistance program, something like Medicaid, for example, or SSI. Well, if that happens, you don't want those people to inherit money in their own name because they have to be below a certain amount of limit in assets, and you don't want them to have undue harm by kicking them off of those benefits. It does not mean you have to disinherit them, but there are very particular ways you need them to inherit, and so you need to make sure that either your plan has those tools available already or that you talk to your estate planning attorney to add those tools to the plan. With a change in the law, the biggest risk is just not having the tools available to you. A lot of times, older plans are sort of grandfathered in after a law change, but it's just sort of like with a new car, for example, right? Just because your car from 1960 still runs doesn't mean you don't want to have the backup camera, right?
Makes sense.
And then the thing that really makes an estate plan just entirely ineffective is not having the assets properly aligned. Like I mentioned previously, with wills only control the assets that go through probate, and that's really not something a lot of people understand. They think, oh, I have a will, I'm not going through probate. But so if you have a specific provision in your will and you really want that to be followed for all of your assets, you have to make sure that your assets actually go through probate in order for that will to do you any good.